Okay. All right, so guys, please God Hashem blesses us that we finish Bava Kamma. We've got a daf and a half yet, and we need Hashem's blessing. Please God Hashem blesses us because negative forces sometimes intervene, especially at such an auspicious moment of completion. So we need to do that, and then we've got a break until the 1st of Elul, which gives us a few months break. I need it. I'm sure you all need it. And what's going to happen is when I come back is I'm going to deal with different methodologies of learning from Rabbi Ron Cohen, etc., to work out how to give everything from Daf Shavua to Daf Yomi. I need to just master certain types of pacing and content before we choose the Masechta. Yaakov?
Was El Al founded in Elul? Because it's a similar, they're the same letters, just the vowels different.
Yeah. Did you ever think why during the 3 weeks? I said, a Frum person said to me, you're not allowed to go. I was in Renana. You're not allowed to go to the Mardi Gras because it's during the 3 weeks or whatever. I said, well, why did Hashem make Yom HaOtzmaut during the 3 weeks? You got to ask him that.
No, the Sphira.
Sphira. I mean, it was just funny. It was just funny, Kev. That's all.
Yeah. No, sure.
All right, so let's go through this very quickly, and then you can teach with pleasure. It just helps me with the pacing if I can hit the ground running. All right, Arthur, just put your thumb up. I know you can't attend with face. Just I know where you want to be. There, something, some flare, some signal. Arthur? Okay, good. Right, let's go. Let me just check that it's recording, in fact, and I'm not doing my stupid stuff.
Yes, it is.
Okay, good. All right. So the Gemara recounts another incident concerning an informer. There was a certain person who showed Rabbi Abba's silk adornment to the officers of the king, and they confiscated it. Rav Abayu, Rav Chanina, Bar Papi, Rav Yitzchak, Navcha were sitting in judgment on the informer, and Rav Ilya was sitting near them. The three judges thought to rule the informer liable on the basis of that which we learned in the Mishnah in Bechoros 28b, and that was as follows. If one adjudicated a monetary case, and he ruled not liable the one who is liable, or ruled liable the one who is not liable, or if he ruled tameh that which is tahor, or if he ruled tahor that which is tameh, what he has done is done, and the judge must make restitution from his own property. So what does it have to do with these three judges on the fact that they have to make restitution? So very, very similar. That Gemara is comparing conceptually two different cases. Now, the one is if you have a case of three judges and they made an erroneous decision of law. What did they do? They had causative damage. Why? Because they did not take from the one party and physically steal it. Their words, their mere words, created the damage by setting forth in motion the halachic ruling. And causative in nature because A, it wasn't direct, B, it was speech, etc. So it's almost grammar, indirect. And therefore we're saying that if there are three judges that make an erroneous decision, it's very similar to this case of judging an informer guilty through causative damage. So Rabbi Abayu, Rav Chanina Bar Papi, and Rav Yitzchak Navcha are not basically in error here. What they're saying is when they realized there was a certain informer that caused the king's officers to confiscate Rabbi Abayu silk adornment, the reason that they ruled him as guilty, this informer, is because they learned from Bechoros 28b that even judges, when they render causative damage through speech, they have to make rectification by paying. So that's where they got the basis of this from. Now, in all of these cases, and I was giving you examples of one who judged somebody liable who was not liable, or the other way around, one who ruled somebody not liable who was liable. Either way, it cost money. It either cost the defendant money or it cost the plaintiff money. If the defendant was ruled liable and in fact he was not liable, it cost the defendant money. If the plaintiff won money through a libelous action and in fact the defendant was not liable, that cost either the plaintiff or the defendant money, depending which way round it is. If you rule something impure, that which is pure, that's also going to cost money. And if you rule something impure, that's pure, that also costs money. We're going to go through why. But that is the reason, because of the causative damage of judges, which is speech, that these three judges ruled the informer guilty for indirect damage or causative damage for rubber bias or confiscation. Okay? Now, Rav Ilya said to them, this is what Rav said regarding the Mishnah. Now, let me just tell you what that means. The judge must, so what it's saying is, in all these cases, the erroneous ruling caused financial harm. That's the bottom line. So obviously, in all cases involving a monetary dispute, where one of the judges or multiple judges awarded money to one who did not deserve it, or alternatively, conceptually, denied an award to one who did deserve it. So in other words, it was given to one who didn't, or denied an award to one who did. If you're looking at the ruling of Tumul Tara, it still brings about financial loss. How do you know? Because if you take tahor produce and it's pure and you rule it tameh, spiritually impure, then the owner is not allowed to use it. Okay? And then often what happens is that impure produce is put with other impure produce. So in truth, when it was pure, it now has become impure. And if you want to say that tameh produce, which is impure, becomes tahor through an incorrect pronouncement, the owner subsequently thinking it was pure, intermixed it with a less amount of pure produce, and therefore it was mixed again, and therefore you've rendered the produce forbidden. So both tameh rulings and tahor rulings cause damage to the owner of the produce. So the Mishnah rules, what is done is done. So what does this actually mean? Well, it means that his verdict stands and you can't reverse it. This is what you guys have got to remember. If a judge rules a verdict, he cannot reverse it. So he can't compel the one to whom he wrongfully awarded the money to return it. Nor can he undo the financial damage caused by an erroneous ruling regarding the tumah status of produce. So it's the judge himself who has to make restitution for the damage from his own pocket. Okay, is that clear, guys?
Yeah, if he makes a mistake.
Yeah, if he makes a mistake and he awards money to the plaintiff, he can't take it back from the plaintiff and give it to the defendant. If the defendant is out of pocket, the judge has to make restitution. If he
who determines that there's a mistake? How's that determined? How do they work it out that there's a mistake? Was the judgment's made?
It could be an appeal process, Gav. There are higher courts we learned in Sanhedrin. It's an appeal process.
Yeah. See, there isn't. That doesn't. You're right, and that doesn't exist today, which is the problem. There is no appeal court.
Yeah,
it's
it's a huge problem in Judaic law.
Yeah.
So, what we are saying is, Rav Ilya said to them that they made a mistake the way they ruled this Mishnah, because according to that Mishnah, it's inferred that if the judges make a mistake by causative damage of their ruling, the judges have to make restitution. They can't reverse their judgment at all. So what happens is Rav Ilya said, Rav has told these three judges that that's a mistake, because it's only stated in a case where the judge took the money in his hand physically from one party and gave it to another. Otherwise, the judge is exempt. So, for example, according to Rav, he's saying that the judges made a direct damage, not causative damage from their ruling. So let's just tell you an example of how it plays out in each of those four rulings. Let's look at the first case. If the judge ruled one liable and that party is not liable, okay? In that case, he took the money from the defendant with his own hand and gave it to the plaintiff. So that constitutes an act of direct damage. Let's look at a second example. In the case where he ruled not liable on one who is liable, the defendant had given the plaintiff an object as security for the debt. When the judge declared the defendant unliable, he took the security back from the plaintiff and returned it to the defendant. Again, an act of direct damage, because his hands were involved in the process of payment. Let me give you a third case where the judge ruled tameh, impure, that which was tahor, pure. The judge made his ruling concrete by touching a tameh sheretz to the produce in question to make an official ruling, and then for that touching of the sheretz to tameh tahor produce, made it tameh, okay? And therefore, if you look at the last case, where the judge ruled tahor, pure, that which was tameh, impure, he himself mixed the produce in question with the owner's pure produce. So all in all, the judge perpetrated the damage with his own hands. It wasn't merely the product of his words. That's according to Rav. And when Rav Ilya argued that that's how Rav explained the case of the judges in Bechoros 28b, he said that they can't render this informer liable on the basis of this Mishnah for Rabbi Abba's sulks to the officers of the king. So, because it's not, in other words, you can't use this Bechoros as a source. So, unable to decide the question, the judges advised Rav Abba to take his complaint to the other sages. And they said to Abba, go to Shimon ben Eliakim and Rav Elazar ben Pedas, who judges the laws of Garmi, meaning they were specialized judges who dealt with issues of causative damage, and they would know the halachic source at which to make sure that the informer would give Rabbi Abba back his money, and they would obtain payment for you. So Rav Abba went to them, and they ruled the informer exactly as they said, liable on the basis not of the Mishnah in Bechoros, but on our Mishnah. What's our Mishnah, Kevin? Our Mishnah states, if the field was taken on account of the robber is obligated to provide the owner with another field. And this Mishnah has also established the second part of our Mishnah, Kevin, as speaking of someone who showed the field of another Jew to extortionists. So it teaches that one who causes the confiscation of his fellow's property is liable. In other words, you learn it from our Mishnah, not in Bechoros 28b. Does that make sense, guys? This should be fairly straightforward. Guys, any questions? Pretty straightforward.
No, I'm listening.
All right. So, Kev, any questions? You understand?
Yeah.
Okay, very straightforward. They knew that you can judge the law of Garmi causative damage, except we needed to know it was from our Mishnah, not but from Bechoros 28b, because according to these sages, the judges that err in decisions are liable for causative damage in Bechoros, but if there's a dissenting opinion of someone as great as a ton of Rav, then he's saying that the judges personally got involved in switching money from the defendant to the plaintiff or vice versa, or deposit, and then creating impure produce from pure produce by labeling it as such and sticking a sheretz in it to make the declaration, or mixing something which they said was pure, which was actually impure, with other pure produce, and therefore selling all of the pure produce. But if there's no action involved, Rav said, we don't learn causative damage from this. There are other opinions that say yes. But because they're held by Rav, these three great rabbis, and Rav Eliab made it to their attention, they had to get another source from our Mishnah. Okay? And just remember in future, Rabbi Shimon ben Eliakim and Rav Elazar ben Pedas were expert judges on the laws of Garmi, which is causative damage. Now the Gemara recounts another incident. There was a certain person with whom a silver cup was deposited for safekeeping. So the thieves came upon this custodian and threatened him harm, and therefore he took the silver cup and gave it to them, thereby saving himself. And then he came before Rabbah to be judged, R-A-B-B-A-H, and Rabbah exempted him from paying. And a buyer said to Rabbah, but this person is one whom saved himself with the property of his fellow, and he should be liable to pay. Because we learned in the beginning of the 117th daf that one who saves himself for somebody else's property is liable to pay according to some opinions. Okay, and we said that was a case generally when you handed it to the extortionist, Kevin, with your own hands. If you told the extortionist where the item was, that's considered garmi, causative damage. But if you hand it to the extortionist, it's considered by most opinions that you're still liable, even though you were being threatened by idolaters and extortionists. So Rav Ashi later explained Rabbah's rationale, and Rav Ashi said regarding this is that we have to examine the circumstances. If the custodian is a wealthy man, we have to assume that thieves came with him in mind as a shakedown. Therefore, if he saves himself by offering the property of the depositor, he's liable to pay. If, however, the custodian is not a wealthy man, and that we assume that the thieves knew that the original owner was wealthy and he had the silver cup in mind, the extortionist, the thieves, since their objective was the silver cup, he can't be held liable for giving it to him, the thief, because they wanted the silver cup no matter what. They weren't interested in the custodian or his own personal money. And since the objective was the cup, because they knew the original owner, not the custodian, is wealthy, he didn't use his own money to save himself. To the contrary, guys, his withholding the cup would have meant sacrificing his own life for the money of his fellow. And no one is obligated nor permitted to make such a sacrifice. Therefore, although he physically handed the cup over to the thieves, he's not liable to pay in that case. Okay? Now, if you remember, there was a dispute between the Rishonim concerning a person who was forced by extortioners to physically hand over specified property belonging to his fellow. If you remember, the Rif ruled that this person is liable, and Rabbeinu Shananel ruled him exempt. According to Rabbeinu Shananel and his supporters, he claims that the Gemara supports the view of exemption. Why? Because Rav ruled that since the thief's objective was to obtain the cup, the custodian is exempt when they physically hand it over, because they already had their eyes on it, if you remember last time, like with the case of the wine. They were taken over to the cellar, and then the thief said, well, help us with these wine, but they already made up their mind to hand it over. It wasn't as if the informer handed over the assets of his fellow without being prompted, and therefore that's direct damage. This was, from the extortionary point of view, already considered burnt money. But it's the same with this particular case under dispute, because the extortioner specified this particular property, which meant that the custodian should be exempt even though he handed it over, because they weren't interested in extracting money from the custodian, and therefore the custodian did it to save his money. They were only interested in the owner's particular property as he was wealthy. Now, Tosfot, who agrees with the Rif, actually rejects the proof because they maintain that the case of a custodian, though, is different, according to Tosfot. Because when one deposits an item with a custodian, he has to do so in understanding that if thieves come on account of the item, the custodian may save himself by handing it over. In other words, it's part of the agreement of custodianship. So it's different to if a normal Jew was an informer to extortionists. Then action orientation would mean he's culpable, and just causative damage by him saying where the item was, he's not liable, unless he showed them where the item was first, and then they forced him to carry it. Okay, that's fairly straightforward. So, because the custodian was not a wealthy man, Rabba exempted him from paying, because they clearly came after the object, knowing the original owner was a wealthy man. If a custodian was a wealthy man, it would have meant that he would have satisfied the thief had he used his own objects, and therefore he paid with the actual owner's money or item in order not to pay, and therefore he has to pay. It depends on the wealth of the custodian. Let's give you another incident. There's a certain person with whom a purse containing money was deposited for the redemption of captives. There's a specific mitzvah in the community where they collect money, and if a Jew has been kidnapped by a non-Jewish group of bandits, that money is used for the redemption of the captives, or the captives specifically. So it says thieves came upon the custodian of this purse of money meant for redemption of captives and threatened him with bodily harm. He took the purse and gave it to them, thereby saving himself. And therefore, this custodian of the redemptive money for captives came before Rabba for a ruling to be judged. And basically, Rabba exempted him from paying. And the buyer said to Rabba, but he should pay because he saved himself with the property of his fellow. Therefore, he should be liable. And Rabba said to him, you will not find a better example of redeeming captives than this. Therefore, the money was used precisely as intended. Therefore, he not need repay. In other words, he himself was a captive of these thieves. They were going to torture him, and they wanted to do him harm. So therefore, the money set aside in order to free captives was entirely used for its intended purpose. But the Gemara's got a different answer to that of Rabba to a buyer. They say that the reason why the custodian was exempt is because he was not wealthy. So therefore, Tosfot deduced from this that, in fact, if he were that this captive was in fact wealthy. So what do you do with this captive where they steal the purse from redemptive captive money, the custodian? According to Tosfot, is that were it not be for the safe that he was a captive, he's got to be liable to replace the contents of the purse. In other words, funds intended for the redemption of captives are generally set aside for captives who are indigent. In other words, they're poor, and they can't redeem themselves financially. So this custodian that was wealthy, why is he entitled to use it according to Tosfot? Because at the moment that the thieves came upon him, he didn't have his banking cards with him, he didn't have his assets with him, and therefore he was just as indignant and vulnerable as any other poor person, because he didn't have money on him. And therefore, to free himself from captivity, he had to give the money over. And according to Rabba, this then fulfilled the edict of using the money to free a captive. But you've got to bear in mind that if this money was set aside to free Kevin, a particular captive, the person that was earmarked for this redemption has to be redeemed, and then the person that got rescued from that money, the custodian, has to replace it. Do you get the rules?
Just go through it one more time. I think I do, but go through it again.
Kev, you want to give me the rules? Kev?
What's that? The rules for what? Sorry, I've been listening, but haven't been absorbing everything. Sorry.
No, this is not a criticism. I just obviously saw you were a bit tired. So what I'm saying is, what's the rules here about can you use a captive's purse or not?
A captive's what? To pay off a debt?
All right. So let me just repeat this concept. Concept.
Yes, you can. Sorry,
What Arth?
Karen. No, the concept is yes, you can. Okay, if you don't, if that's what the intended purpose was, first of all, and secondly, if you don't have any in like your any other payment, like you have your credit card and your whatever to sort it out and to save a life, save your life. That's basically what I understood.
Okay, so Arthur got it more than anybody else, so that's pretty good. Okay, so concept number one, Kevin, was as follows: is that if there's a custodian, all right, according to Tosfot, there are different rules that apply to a custodian. If a custodian is putting his life at risk, he doesn't have to give his life in order to save that of his client or his friend, whether he does so for free as an unpaid custodian or a paid custodian.
You know, but if it's the item is looking for gets stolen
No,
under duress or
I'm saying thieves or robbers put a gun to the custodian's head and say, "Give me the silver cup belonging to your client or your friend that you've got in your custodianship. We'll put a bullet in your head." He has to give it over. Why? Because his job as a custodian is not to give his life up for his fellow Jews' possessions. He obviously has to take a shavua, an oath as to this is what happened. Okay. Now, in terms of does he have to replace it if he's an unpaid custodian? No, because he's doing the person a favor. As far as a paid custodian is concerned, the rule is, would you have to pay for the theft? And the reality is it depends on certain situations. One of the situations is if the custodian was a wealthy man, then he merely used his clients or his fellow Jews' silver cup in order to save his own money. And therefore, on that basis, he has to replace it because the thieves would have been satisfied with a similar amount from the custodian. Okay? If it's an unpaid custodian, he doesn't have to do that sort of favor because he's not getting paid for the job of looking after things. Otherwise, nobody would ever volunteer for unpaid custodianship. But paid custodianship is only off the hook if there's no money that the custodian has. He's not a wealthy man, because it meant that if they know that the custodian wasn't wealthy, they came in mind for the property of his fellow, not for him, and therefore him risking his life he doesn't have to do as a custodian. That's according to Rav Ashi, who explained Rava's rationale. Now, there's the same issue as far as the case with Rabba. Now, Rabba is saying here that what happens if somebody's the treasurer of community funds for redeeming a captive, or captives plural? Well, if this custodian or treasurer of the captive freeing money is himself kidnapped, Rabba said he doesn't have to pay back because this is exactly what the money was intended for, is to release a captive. However, if the money was earmarked for a particular captive, then the person would have to pay it back in order to free this other captive. Now, if he was a wealthy man, how could he use the money in order to free himself and not be under any obligation? So the reality is, at that point in time, he's treated as a poor person because he doesn't, as Arthur said, have access to his money. And therefore, according to Rabbah, it's done the job of freeing a captive that in that point, once he's bound up and he doesn't have access to his other assets, it saved his life, and he's treated as any other indigent poor person. And therefore the money is used what it was meant to use for. And it's entirely in line with its intended purpose. It's only a case of if it was intended for a particular person, that person still needs to be redeemed. Okay, now let me just recount the final incident and then we are done. I've got 7 minutes. Let me just fly through it. Okay, the Gemara recounts a final incident. There was a certain person who hurried and brought his donkey onto a ferry boat before the people started boarding the ferry boat. The boat then filled with people, okay, and the donkey, because of its weight and was on the side of the boat, was about to capsize the boat. Obviously, people have the common sense to be in the middle of the boat and be weight-wise distributed evenly, but this donkey was a bit wild, and because it was going to and fro with its weight, it was going to capsize the boat. So another person, perceiving the danger, came and shoved the donkey of that first person into the river, and it drowned. Okay? Now, the case came before Rabba to be judged, because he technically saved the boat and all its passengers, and Rabba exempted him from paying for the donkey. And Abaye said to Rabba, but if he's the one who saved himself with the property of his fellow, he should be liable to pay. We're all saying, according to Abaye, that it's not that you can't use the property of your fellow to save your life, but you have to pay it back. We know that from Sanhedrin. So Rabba said to him, listen, if you look at this case in context, from the beginning, the donkey's owner was legally regarded as a pursuer because he put everybody's life in danger by not assessing the situation, being the first to board with his donkey, and not seeing if the ferry boat could take the donkey's weight, nor the donkey's wildness. So it's entirely permissible to destroy a pursuer's property in order to thwart him. Therefore, one who threw the donkey overboard is exempt in order to save themselves in this particular case. In other words, that's why the Gemara goes through this detail that he hurried the animal aboard before people loaded, because he feared that if he would wait, the other passengers would prevent him from boarding, and therefore he was happy to put the other people in danger. Okay, so the Gemara provides the basis for Rabba's ruling. In exempting this person, Rabba follows his opinion expressed elsewhere. What was that opinion? Is that if a pursuer was pursuing his fellow with intent to kill him, and the pursuer broke some vessels during the pursuit, whether those vessels were the property of the one being pursued or the property of any other person, he is exempt from paying for the breakage. Why is he exempt? Because he's liable to pay with his own life. How can you make the pursuer exempt? Because he can be killed by the pursuit, by a person trying to stop this pursuer, and this liability exempts him from any monetary damage or obligation occurring during the period. Okay, so how do we know this? Let's just see how much time we have. We've got about 4 minutes. Quickly, let me go through it. Because he's liable to pay with his life. As a pursuer, he now endangers himself because he can be killed by the pursued or a person witnessing the pursuer. And Kim Labadi Rabba Minay means if he puts himself in danger, whether he's the pursuer or the pursued, he's not obligated to any monetary obligation occurring during the period at which he's going to commit a capital offense or himself be liable to a capital punishment of dying. So all we are saying is as follows, is that if the one being pursued broke the vessels of the pursuer, he's exempt from paying for the breakage, because the pursuer's money should not be regarded as more precious than one being pursued by the pursuer's life. In other words, if the victim is permitted to save his life by killing the pursuer, he's certainly permitted to save himself by destroying the pursuer's vessels. So it follows then that he need not reimburse the pursuer for their destruction if he fell over them while escaping persecution from the pursuer. But if the one being pursued broke the vessels of any other person, he's liable, because it's forbidden for a person to save himself with the property of his fellow unless he reimburses the person for the property. And if one pursuer was chasing another pursuer to save the intended victim, and he broke the vessels in the process, whether they were the vessels of the one being pursued or any other person, he's exempt from liability. Why? It's not based on the strict letter of the law, because if you were going to be a good citizen and stop somebody from being killed by a pursuer, but you made him liable for any of the damage during a chase, he's not going to get involved. It's just like a custodian that's unpaid that you're expecting to do all this favor for you to look after and feed your dogs while you're overseas, and you're going to sue him if your dog gets poisoned. He's going to say, pal, found somebody else to look after your dogs, take them to special kennel. So in that particular case, the rabbis decreed that a rescuer not be held responsible during the rescue because it would deter one from rescuing his fellow Jew. In any rate, guys, it doesn't matter, because Rabbah holds that one being pursued breaks the vessels of the pursuer or drowns the donkey in order to ensure that he and the other passengers escape. Otherwise, the donkey could have sunk them all. So that's what it was based on. We've got 1 minute and 15 seconds. Let me just tell you where it's from. In Exodus chapter 22, verse 10, and it's the same in Sanhedrin. If a thief is discovered while tunneling into a house and is struck and dies, he has no blood. In other words, the taking of his life is not treated as murder. Because if somebody breaks in your house, you must know that they're prepared to kill, because they don't know if they'll be killed by the homeowner, because it's natural for a homeowner to want to protect his property. And therefore, any damage that this person does in Sanhedrin 74a or Brochus 58a, while the thief or the pursuer's life is in danger by his career, he doesn't have to pay for that breakage. If he takes something, he has to return it. So that's Kimle B'di Rabbi Minay for that, because there's a capital risk to his life, whether it's an offense or the fact that he could be killed by the homeowner, and therefore he's not responsible for damage or breakage during that time period. So if you bring a donkey on board that's unfit for transport, you don't have to reimburse the owner